Welcome, 2 days in a row. Welcome to TGIF. I hope you have poured your favorite beverage. I sure have. It's been a wild week between Vallow, Daybell, and Murdaugh. We've just had a lot of developments going on. Today we're going to focus on the Vallow case, but I would be remiss if we didn't talk a little bit about Murdaugh because he got sentenced. Um, I'm telling you what, South Carolina does things a lot different than we do in a lot of other states because he was found guilty on one day and 9:30 the next morning they imposed sentence. In a lot of states, it would have taken a little more time. Usually the district attorney has to notify the victims and the victims have to be able to prepare impact statements. And so in general, there's a bit more to it than you'd think in South Carolina. But nonetheless, he was sentenced to 2 life sentences and they will run consecutive, so one after another, which means that he will die in prison, undoubtedly. There's no, I don't know whether or not involved in that sentence is an eligibility for parole. But in a consecutive sentence, what happens is you would serve the first sentence, and even if you came up eligible for parole, it's likely you would have to serve the second sentence until you were eligible for parole as well. So um, I'm not positive how it works in South Carolina, but that would be my guess. So no question, he's going to spend the rest of his life in prison. And they still haven't dealt with the financial crimes. Because he pled or he was so forthcoming and made all those admissions on the stand, I think it's very unlikely there will be trials on the financial crimes. I'm sure that he will be entering a plea shortly. So let's talk. I always like to chat a little bit and fill you in on stuff before I start taking questions and comments. So I'm going to talk a little bit about Vallow Daybell, and then we are going to invite your questions and your comments. It's very much easier on our mods if you hold your questions until we're ready for them, because then they can find them quicker in our chat. Because our chat's moving pretty quick these days. That's because there's so many of you in chat, and thank you for that. Before I dive into Vallow Daybell, I want to just remind y'all that there's other stuff going on. We have let me see if I can turn just a little bit. We have our True Crime Quilt Guild. You can see the squares are up on the wall. I have a couple more I'll be putting up here very shortly. And if you want to join in, it is suitable for beginners. I'm doing some little how-to videos that help out with how to put the squares together. And I'll continue to do that. I've got a couple more we need to post. And then if you want to join, it's not too late. The pattern, the link to the pattern is in our information in our show notes. So think about joining us if you'd like. It was just sort of a fun thing to do while we were sort of waiting for the Vallow case to get underway. We know that the Vallow Daybell cases have been severed. The judge, I will say that I think Judge Boyce is finding his feet a little bit in this case, which I don't know about you, but I'm a little relieved about. I do think that he gave some real thought to whether or not to sever these cases. I know that he has been very resistant to severing the cases as time has gone on and has denied severing the cases a couple of different in a couple of different motions that John Pryor filed. So I realize that there are many reasons why the prosecution and the judge both want the cases tried together. It's more efficient for the court. It's less likely that you're going to come up with rulings that are not the same, different outcomes, different evidentiary rulings, and more likely that there'll be continuity and consistency in the case. For the prosecution, it means they only have to put the case on once. They only have to bring in all their witnesses once, which is important. As we saw in the Murdaugh case, there were quite a few expert witnesses that came in, and they were people who had to be flown in from out of town and who had to be put up, and that's an expense for the defense if they're not going to get to them quickly. In Murdaugh, they ended up, when they put Alec on the stand, his attorneys asked to interrupt the cross-examination in order to put on a couple of experts, and the prosecution said absolutely not. So they ended up having to keep those experts over the weekend, which was a very big cost to them. Same thing could happen in these cases, in the Vallow Daybell case, and it is going to be an expense for both the state and the defense. That, of course, for the state is cut in half if they're only trying the case once. So there were a lot of reasons why you would want, from their standpoint, the cases to be tried together. From the defense standpoint, it makes it is way helpful for at least the second person whose case is being tried to go to have the cases split, because you get a look at the prosecution's evidence ahead of time, and that can be hugely helpful. For witnesses, it means that they get to tell their story twice, and they get to hone their presentations. They know what to expect, and they know what they're going to be asked, and so they can be more practiced. That doesn't mean that they're shading the truth or that they're not being truthful about things, but it does mean that they're less likely to say things spontaneously. So the defense certainly Chad's attorney, who is going to get the second bite at the apple, has to be happy about that ruling. I'm sure the prosecution is not at all happy with that ruling. But I have to say that this is firmly at the feet of the prosecution. We know that there was DNA evidence that was discovered when the state, now this is DNA, this was physical evidence that they had had since the children's bodies were recovered in 2020. We also know that during the period of time where Lori Vallow was incompetent, the prosecution was concerned about reaching an agreement having to do with the consumptive DNA. Now, you might recall that the prosecution brought this up and said, we have at least 2 samples that are so small that it will consume the entire sample in order to test the DNA. In general, what happens is the lab reserves a portion of the sample so that it can be retested if, in fact, the state requests it, or the defense requests it. They can have the sample completely retested. They can have the raw data analyzed by an expert. There's a number of things that they can do. So because Lori Vallow was incompetent, the state was hesitant to go forward with the issue of and have this DNA tested, because she and her attorneys had not had the opportunity to weigh in on the consumptive testing. So it wasn't until she was restored to competency that they then came to an agreement for how that consumptive testing was to be done. Here's the part that made it more complicated. When they took that duct tape and began removing the sample from it, they discovered 2 more small hairs caught in duct tape. Now, duct tape is notorious for being a repository for evidence, for hair, for fibers, for fingerprints, for touch DNA, because it's sticky, because it picks up every little thing. So we have no way of knowing who deposited those hairs in the duct tape. This could have been a roll of duct tape that was in Chad's shed, and it could have anybody's DNA on it. It could have been a roll of duct tape that was in a place where it was exposed to other people. It could have been used by other people. So it's unclear. But what happened was that those samples were discovered. And so the prosecution notified the defense that there were these new samples. They weren't sure there was a sufficient sample to be able to even lift DNA from them. And as it turned out, they could, but they sent it to a specialty lab in order to do that. The results of which just came back a week ago. Now, it's probably no one's fault that the testing revealed these 2 new hairs. I think there'd be a bigger complaint if it were the original consumptive testing they've had since 2020 that hadn't yet been done. But that was done, although it was also done very late. So the judge had said to the both parties, the discovery deadline is all discovery must be in before prior to February 27th. And February 27th at 4:00, so a full day after the deadline, they provided the last of the discovery. And the judge said it was late. The judge also said the results of that testing with the specialty lab were that the DNA belongs to an unknown source. It is not DNA from any of the parties. So that's perplexing. And so the judge said, well, we don't know whether this DNA is going to be exculpatory. We don't know if it's going to be inculpatory. We don't know. And because we don't know, Chad should have additional time to have his experts review that DNA and determine whether or not it helps his case. The problem is that Lori has never wavered in not wanting to waive her speedy trial right. And we've talked at length about this because it's been an issue for months. But at this point, the court has exceeded her speedy trial rights and has been able to say there was good cause for us to go beyond that deadline. But I do not believe that there is any good cause that would result in her case not being dismissed. There isn't any good cause going forward. So now the judge is between the literal rock and hard place, because now he's got to figure out how to give Chad extra time that he's entitled to make sure that this DNA isn't exculpatory, and how to also honor Lori's Sixth Amendment right to a speedy trial. In the grand scheme of things, the speedy trial right trumps almost everything. So the judge has decided that the only way to honor both of those rights and to protect the rights of both the defendants, the only option is to sever the cases. So after months of resisting severing the cases, the judge has ordered them severed. Because of Ada County scheduling and the fact that the judge has done a great deal of coordination in getting this trial to happen in Ada County, in Boise, where the venue was changed, he knows that their schedule is difficult and it's unlikely that Chad's trial will come before the end of the year. That is not even within the realm of possibility for Lori's case and honoring her speedy trial rights. So the judge has ordered the cases severed. As far as we know, there will be a trial starting on April 3rd. The judge has actually said that it would be his preference, and they are trying to arrange to do jury selection the week prior to the trial starting so that the trial can start promptly on the 3rd of April. We'll see whether or not they're able to arrange that with Ada County, but that, I think, is his hope. So Lori and her attorneys are going full steam ahead toward trial preparation. Now, there's no question that Jim Archibald and John Thomas have said from the very beginning they would love to have more time. They really feel like they're at a disadvantage because they have to prepare for a trial within that 6-month window from her arraignment. But they understand that she has an absolute right to invoke her right to a speedy trial and to not waive it. They feel they could prepare a better case if she did, but they're prepared to go forward. So that's the reason why they haven't made a big deal over the new DNA. So I see we had another super chat. I want to remind everybody, thank you so much for being so generous, because all of your donations go directly to our moderators. Our mods, Michelle and Brenda, are with me every week. Michelle is even a little under the weather tonight and still here, so send her some good vibes for feeling better. And I just want to thank everybody who's here tonight. We've got about 217 in chat. Last night, when we went on our surprise live, we had over 400 people in chat. So it was a busy night last night. I know that you could spend your Friday night with in a lot of other ways, and there are a lot of other shows on that you might be interested in as well. So we appreciate that you're here with us, and we appreciate that if you can't watch us live, you're here for the replays. I want to remind everyone, if you are not subscribed, please do subscribe and hit that notification button. If you are enjoying our show, please give it a thumbs up tonight, because it helps us with the YouTube algorithm. I encourage everyone to hit that notification bell to get notifications when we go live, because like last night, we're probably going to have a lot more of these unexpected lives coming up as we get closer to trial. I do want to say that we continue to hear rumors that there are settlement negotiations going on behind the scenes in the Vallow Daybell case. That's not at all unusual. It's very typical for both sides to be engaging in negotiations, and those negotiations could go right up until the jury is seated. So it will be interesting to see whether or not the decision to sever the cases has any impact on those settlement negotiations. And certainly, I think you will see Chad and his attorney continuing to get prepared for trial. A lot of people had a lot of questions about whether or not, now that the case is severed, if they can be called to testify against one another. It's a great question. The answer is Sometimes. It depends. It's a famous lawyer answer. It depends. Um, because Lori's case will go first. She has an absolute Fifth Amendment right against incrimination, and that right goes on until her case is adjudicated. She's either found not guilty, she pleads guilty, or she's convicted. So, what could happen is, because her case is going to be tried first, what could happen is her case could come to an adjudication, and then she could be called as a witness in Chad's case. So it'll be interesting to see how that works out, whether or not the state is going to be interested in calling her as a witness. There haven't been a lot of filings going on since the hearings have been happening and the judge has been giving his findings orally in court. We did have a couple of orders, which I thought were semi-interesting. The judge did issue brief written orders on the motions that he decided yesterday. So the motion to sever, there was a motion to dismiss the indictment or to dismiss the death penalty portion. There was another motion to compel discovery. So the judge did file written orders in those, denying all of those motions except the motion to sever, which was granted. And I thought the judge, in his remarks and his findings on the record, did a really good job of laying out the reasons why, his reasoning for deciding to sever the cases. So there also was an order sealing all of the trial subpoenas. And I had a couple of people send me questions about what the heck is this? So, of course, when you're going to go to trial, the way that you get people to show up and testify is you send them a subpoena. Attorneys have the power to subpoena people. The court has the power, of course, to order people to come. And so it's usually what happens is those subpoenas have to be filed with the court, and anybody can pull them up off the court's docket. But subpoenas include a lot of personal information, the person's address, their phone number, a number of identifying factors. And so it made a certain amount of sense that there was a motion filed asking the court to seal those subpoenas to protect that information. I'm certain that once the trial is over, those subpoenas will be released with the personal information redacted. But for now, the court has ordered them sealed to protect the identity of the people that are being subpoenaed and to protect their confidential information. So that's really the only development that's happened since we were on last night and talked about the big news about severing the cases. But I'm sure that you all have lots of questions, so I'm going to open it up to questions. While our mods are working on that, I just want to remind everybody, subscribe, like, and hit the notification bell. And I just want to say thanks for everybody who continues to join us, who continues to send me very kind messages, and especially great YouTube comments. Hi, Jenny Meow Meow. If Lori is convicted after her trial in April, can she be compelled to testify against Chad in his trial? Is there a pro or con to the prosecution going or not going that route? Well, at this point, the prosecution knows what is in the discovery and knows the case better than we do. So it's a little hard for me to be able to tell you whether there's a really compelling reason to have her come and testify. But yes, she can be compelled to testify once her case is adjudicated. So if she pleads guilty, if she's found guilty, if she's found not guilty, any of those, in any of those circumstances, her Fifth Amendment right against self-incrimination goes away and she can be compelled to testify. Hard to say. I mean, I would assume that the defense is going to, their theory of the case is going to be that Chad was set up, that he was the unsuspecting dupe, that he was the guy who was taken in by Lori's feminine wiles, and that he is that he really didn't have anything to do with it. And so, of course, they would be calling Lori to say, no, he was in it up to his eyeballs. So, I mean, I suspect that would be the tactical reason for calling her. I'm going to grab a little sip of my wine here. Trisha the trucker, last night you were in Dallas and today you're in Kansas City. How are you? Do you think it's beneficial for the prosecution to correct and improve before Chad's trial? Oh, absolutely. They're going to be able to refine their case and their theory of the case just as much as the defense is going to learn from Lori's trial. So I think in both cases, they benefit. I think probably the defense benefits a little more because they are the ones who are really going to get a peek at the prosecution's theory of the case. And anybody who's been watching the case knows that Rachel Smith has pushed back on multiple occasions when the prosecution has asked for a bill of particulars and some other things, saying, no, you just want to know the theory of our case. So clearly, they're going to be better off if they know the prosecution's theory of the case. But the prosecution's also got the opportunity to fine-tune their case as well. Question from Elvie. Couldn't Lori and her attorney at the time have come to an agreement about DNA testing even while her case was stayed? Couldn't prosecutors have reached out to Means about this too? Well, yes and no. It's important to remember that a client directs the case. And in something as crucial as a piece of DNA that was going to be consumed, I would have wanted my client's participation. It's not something that I, as a lawyer, would have made a decision for my client on because I would be concerned that she might not fully understand the consequences of that decision. So it's certainly something I would have wanted my client involved in the decision on, and she was incompetent. Whether she was completely unable to participate in that decision, legally, she was incompetent. And so once a person is legally declared incompetent, then there's a legal presumption that they are unable to make decisions for themselves until they are declared competent again. So I could definitely understand the reason why the prosecution did not want to go forward until they had everybody on board and available to make those decisions. Good question, though. Thug nasty. I don't know quite what that means, but it sounds tough. Now that the cases are severed, does this mean your book becomes books, or will we have to wait until both cases are adjudicated? Thank you so much for asking this question. You know, the answer is I don't think it's going to delay the book. If Lori's trial goes ahead as scheduled, then I will have access to a lot of the information, both from the trial and through discovery, because her case is adjudicated, and I'll be able to get a lot of that stuff through Freedom of Information. In Idaho, there's an exception to the Freedom of Information Act for cases that are pre-adjudication. But once they're done, then I should be able to get that information, even though Chad's case is not adjudicated. I'm sure that a lot of the information is actually going to come out at trial. And so books take a while. I've been working on this one and have some parts of it written, but certainly the bulk of it has to be written once the trial is done. So my plan is to take the 6 months after the trial is finished to write the book and to have it in a first draft. I'm hoping that by the time that rolls around, that'll be late in this year or early next year. I'm hoping that Chad's trial will have happened and I'll be able to sort of pick up that information and incorporate it into the book as I go. I mean, the best laid plans, I couldn't have imagined when I moved here a year ago that I'd still be waiting for this trial to start. So, you know, I'm incredibly grateful and fortunate that my editors and my publisher at Pegasus Books has been super patient and has repeatedly said, we didn't want the fastest book, we want the best book. So I'm hoping to honor that and get them a full manuscript by the end of the year. We'll see. That would mean that the book would likely come out next fall in 2024. Trisha, your book is going to be as long as the 7th Harry Potter book with this crazy case. It's possible it could be. I hope not. I hope we won't have to split it into 2 parts just to get anybody to read it. I hope not, but we'll see. Rachel Gamber, question, have any documents been released yet as a result of your motion? Very few. The judge did go back through the things that he had sealed and found a few things that he felt he shouldn't have initially sealed. Those were reopened. But as far as releasing the information in redacted form as I'd asked for, it didn't happen. So it's okay though, because we've set the precedent that we're watching them. And I really do think that following my motions, there was much less sealing going on. So I think that it had that effect, even though we didn't get a lot out of the previously sealed stuff. But once again, once the trial is over, there's no justification to continue to keep those things sealed. So they better get unsealed. I realize that there is some confidential and private information, individual health information, those sort of things that should be redacted and that I certainly would not be publishing. So I realize it's probably going to take them a little while to get their arms around how much of that has to be redacted, but we'll wait to see until the trial's over. Retired RN 43. Question, can you give us an example of how this new DNA could be exculpatory for Chad? Well, sure. It could be somebody else's DNA. It could be somebody who's even just tangentially related to the case. It could be, and some people have said, you know, there's some discussion about the fact that the very last time that JJ was ever seen, David Warwick and Melanie Gibb were there. I mean, it could be some sort of a bombshell that David Warwick's hair is on the duct tape. And so he's implicated in wrapping the body in duct tape. I mean, there's a number of ways that it could be exculpatory for Chad. As long as it's not Chad's DNA, I think, you know, he's got an argument that Saudi, some other dude did it. So, if it comes back and it's Chad's DNA, then that's, to quote the Wizard of Oz, a horse of a different color. So we'll have to wait and see. The point is that regardless of whose DNA it is, Chad has an absolute right to that information and to know that information before he goes to trial. And it's not up to the prosecutor to decide whether he gets that information or not. He's got an absolute right to have the information, to have an investigator or an expert weigh in on the information and to analyze that raw data and come to their own conclusions. So I think the judge was right in saying, I don't have any choice but to give him more time. And Jim Archibald said in the hearing, I would be asking for more time too if it weren't for the fact that we're up against a speedy trial deadline. And Lori Vallow has been very clear about not waiving. So, and I don't anticipate that's going to change. I've had a lot of people ask me if I think that she will now waive her speedy trial now that the cases are severed. I don't think so. I don't think that whether the cases were together or severed was ever a factor in her calculus. I think she had decided long ago she was, for whatever reason, for whatever advice she got from whomever, she was not going to waive her speedy trial. So I don't expect her to do it. If she did, the judge could rejoin the cases and set a joint trial again. But I don't expect that's going to happen. Sabrina, with Pryor and his kids seemingly going full steam ahead, with the Chad was framed by Lori and Alex, do you think Chad would be open to a plea offer if offered? Will he testify against Lori to save himself? So I don't know that he's certainly going full steam ahead with the Chad was framed by Lori and Alex. I think there's no question of that. I don't know. I think whether or not Chad is going to be open to a plea offer is really going to depend on the outcome of Lori's trial and what comes out at Lori's trial. We saw that in the Murdaugh case. And you see it in a lot of cases. We saw it in the Murdaugh case in the form of him making these admissions on the stand and them having a direct impact on the financial crimes that are still charged. And I think it's possible we could see this in Lori's case. They could determine from what comes out at Lori's case that maybe it's a good idea to take a plea before things get worse. I don't know, but I think that that could easily happen. I don't believe that he'll testify against Lori to save himself unless he takes a plea first, because he will still have a Fifth Amendment right not to incriminate himself until his trial happens. So while I could see a scenario where Lori gets adjudicated and then she testifies against Chad, the reverse doesn't really work because he's still got a Fifth Amendment right against self-incrimination. So. Kavita Diva? What made Lori competent? I would think it's being on psych meds and being compliant up till trial is over. Absolutely. What we know is that it's a complex cocktail of psychotropic drugs that are very likely keeping her competent. What we know is that that is going to continue to be a tightrope dance. And I don't know if that's part of her motivation in wanting to get to trial as soon as possible while she still feels okay. I don't know whether that's a motivation, a factor that her lawyers are contemplating. Don't know for sure. But I do know that that the treatment very likely is being on a drug cocktail, and then also um, having a lot of monitoring and a lot of talk therapy and whatever else it takes to keep her on the straight and narrow until the trial happens. So, um, what we know, what we surmise and speculate about her mental health condition is that it is best treated with drugs. So I think that you can assume that she is on a cocktail of drugs. And, we know that those drugs sometimes stop working, sometimes work differently, and that over time they have to be adjusted and tweaked. And so I think the sooner that she gets to trial, the more likely it is that she's going to get through trial and remain competent. Good questions. Since Lori is not charged with anything to do with Tammy, will any reference to Tammy be made at her trial? I don't think that's right. I think she is accused, at least with conspiracy involving Tammy, but I could be wrong because it has been a while since I've looked at the indictment, but I'm happy to pull it up and see if we can double check that. I if she's not charged, I'm not sure that any reference to Tammy would be permitted because I think it would be the infamous 403B character evidence, evidence of prior bad acts kind of thing that we saw in the Murdaugh case and have also heard rumblings about in this case as well. I think that a lot of the conversations that they've had around this 403B evidence had more to do with whether or not they could bring in her charges, the charges in Arizona for Charles Vallow. But now you've got me wondering, and so I'm going to see if I can pull up that indictment. While we talk. Fortunately, my computer searched the Vallow case so darn many times that I can get to it pretty quickly. So I think if she is not on the indictment as to Tammy, then I think they would not be able to bring that in because it would be, there is the indictment. Because it would be evidence of bad acts that she's not been convicted of. So let's take a look here. So count 1, first-degree murder, conspiracy to commit first-degree murder for Tylee, first-degree murder for Tylee, conspiracy to commit murder for JJ, and murder for JJ. And then first-degree murder. Chad is the only one on first-degree murder for Tammy. But Lori is charged with conspiracy to commit murder for Tammy's death. That's what I thought. So yes, Tammy's death will come in. So hopefully we answered that question. Yeah. Hey, Speakeasy Lounge. Hey, if you haven't discovered Speakeasy Lounge, you need to go and discover her YouTube channel. She does awesome. It's all about music, and it's a great channel. You should definitely look her up. But if it's just that Chad's DNA is not on the tape, that doesn't mean he wasn't involved, right? No, it doesn't mean he wasn't involved, because he's certainly implicated in all the conspiracies, even if there's not any direct evidence that he was involved in the actual death of JJ. That's where the DNA is. So presumably they're looking at DNA caught in the duct tape that JJ's body was wrapped in, so it would be whether or not he was directly involved with JJ's death by helping put the duct tape on. That doesn't mean that he's off the hook, because there's still a conspiracy, all these conspiracy to commit murder charges. So, and certainly he's still on the hook for Tammy's murder as well. So it's going to be really interesting to see how if you were watching the Murdaugh case, and they talked a great deal, and we did too, about circumstantial evidence. Direct evidence is, I saw him kill the children. Circumstantial evidence is, the children were found in his backyard. His DNA is on some of the equipment. He sent the text message about the raccoon. All of these things where the circumstances point to something you can infer. For example, in the Murdaugh case, the fact that there was a video with his voice on it 5 minutes before when it's likely they were murdered, you can infer that he was there. So circumstantial cases like links in a chain, and every one of those links has to connect in order to form that chain of inferences, to infer from that. If XYZ is present, then this must have happened. In order to get there, you have to be able to connect all those circumstantial pieces. So we don't know at this point how the prosecution is going to connect up all of those links, because they really do have to connect. I think in the Murdaugh case, there was some concern that the prosecution had not made those connections clear enough that people could make the leap to, this was a terrible day and he snapped and murdered his family, because of all of these things that were sort of closing in on him. And I think it's obviously a direct case is an easier case, but direct cases rarely go to trial because there's an eyewitness who saw them do something. Circumstantial cases are the ones that go to trial. Circumstantial evidence is just as good as and just as valid as direct evidence, but it requires more work for the prosecution and for the jury to make those connections in that chain of reasoning, to get from this to that to this. So no, just the fact that Chad's DNA is not on the tape doesn't mean he wasn't involved. There's still all these conspiracy charges. There's still all of these other issues to get to. But as I say, I mean, it's something else that the defense could argue. This just goes to show you that he wasn't involved in the actual hands-on murder of the children, that it was somebody else. So. And mods, if you get a moment and would like to drop the Speakeasy Lounge link into our chat, that would be awesome, because she has a really fun channel that deals with music. Amy in Boston, do you think Lori will pull something in order not to be prosecuted alone, or is this a done deal? No, I don't think there's much she can pull at this point. And to be honest, a lot of people think that somehow she does not want to be tried without Chad. She wants the opportunity to sit in the courtroom with him. I don't buy that. I think that she has been really clear from the beginning that she wanted her day in court. I think she still absolutely believes that Chad is a prophet and that she is one of the 144,000. And I think that she absolutely believes that God is going to deliver her from this, and that these charges are merely an inconvenience. I don't know at this point if she's convinced that, like the Apostle Paul, that the earthquake will happen and the prison walls will fall down and she'll walk out. But I suspect that that's her mindset. So I think she feels like the sooner she gets this over with, the better. And I don't think that she is tied at all to having the trial with Chad. Rachel Gamber, do you think the digital evidence will be as strong in the Daybell case as it was in the Murdaugh case, especially since they found the children's bodies via Alex's phone? I think this case is going that the digital evidence in this case is going to be pivotal. What I want to remind you is that Alec Murdaugh was a prosecutor. And he also was someone who he did a lot of civil cases, and he understood. And I think that a couple of the other lawyers who did that sort of work made clear that they're tech savvy. They understand how technology can work to prove your case. And still, the electronics in Alec Murdaugh's case sunk him. There's no question that would have been an entirely different case had there not been a video on Paul's phone with him talking in the background. Many people have said that was Paul's vindication from the grave, and I can't disagree. I think that would have been a very different case without that video. My point is that Alec Murdaugh was a savvy, careful guy. He left his phone at the house while he was down at the kennels. I mean, there were many places where he did appear to be trying to cover his tracks a bit with the electronics and the digital footprint. These people, Lori Vallow was absolutely not tech savvy. She was so not tech savvy that when she wanted to send her son Colby money through Venmo, she had to have Tylee do it, and Tylee had a Venmo account because Lori didn't know how to do it. So I think it would be if the electronics tripped up somebody as savvy as Alec Murdaugh, I think we can assume that the electronics are going to be pretty damning when it comes to Lori and Chad, because neither one of them were digital mental giants. So I think that I have said all along that I thought that the digital evidence in this case was going to be really pivotal to the case. So it will be interesting to see what else they have. We've seen little spatterings of it. We've seen some text messages between the parties. We've seen some other things. But I think we've seen the tip of the iceberg. I think there is a tremendous amount of digital evidence that's going to come into play. So, good question. Hey, Bo Peep. Bo Peep, you're such a faithful viewer, and we appreciate it so much. Hey, 348 folks in chat. Thanks today. Thanks for being with us. And thanks for being faithful followers on a Friday night when there's lots of other things you could be doing. Question from Bo Peep. Did Chad ever write about people being lighter or dark or zombies in any of his books, or what he felt about getting rid of them? You know, that's a really good question. And I have to be honest, I find Chad's books really hard to read, and I have not read them all. Before I finish my book, I will have read them all, because I think those are important questions to ask. Now, we do know that he got involved with Julie Rowe. Julie Rowe was involved with a guy named Eric Smith, who got quite involved with her and her movement, and that Eric Smith and Chad Daybell all were friendly. Eric Smith was from Rexburg, and at one point there was a group of people who were meeting regularly, like weekly, to talk about a lot of these concepts that were sort of offshoots of LDS faith. And I know that within that milieu, there were conversations about light and dark and zombies, um, people being inhabited by evil spirits. And that is not particularly a departure from mainstream LDS teachings. So, but I don't know for sure whether in any of his books, I've read a couple of the early ones, but I have not sort of gotten into the real apocalyptic battle books, where I suspect that would come. So good question, and I promise I will read them. They're just hard to read. Anybody want to help? Mary Howard. How are you, Mary? Hasn't many of the Chad followers said he was the spiritual leader of the group? How can anyone say he was framed under those circumstances? Well, I think that's a really good question. And the other thing that I will say is that I have every reason to believe that this group of people with similar mindsets, I'm not going to say that Chad is their spiritual leader, but this group of people with very similar beliefs and mindsets is still very, very much alive, and very much alive in the Rexburg area. They sort of disappeared into the woodwork early on, but I think that as the case has drug on, they've sort of come back out to see the light of day. So I think that they are. I think that there's definitely still folks out there that share this mindset. I don't, within this small group of people, Zulema, Alex, the Melanies, and a handful of other people who we've heard their names come up, Christina, Nicole, a few other folks. I think within that group, they felt that Chad was the visionary and was a spiritual leader, and felt that he was on par with Joseph Smith. But I'm not sure beyond that small group how many more people would have claimed that he was their spiritual leader. And I agree that it is hard to understand with some of the communications that he had with people, giving them blessings and all of those things, that people wouldn't think that he was in some way a spiritual leader. Hard to understand how he could say he was framed. But I think there's an argument to be made that just because you claim to be a spiritual leader and a visionary doesn't necessarily mean that you murder people. So most spiritual leaders don't, unless you're Jim Jones. So I think that would be the argument the defense would make, is that regardless of whether he thought he had spiritual gifts, most spiritual leaders don't murder people. So, but Janet, do you think that, like Alec Murdaugh, Lori will testify? I don't think so. I think that her lawyers will resist putting her on the stand at all costs. Ultimately the decision is the defendant's, and she could just say, no way, I'm going to get up there and tell my story. And that would be incredibly entertaining and interesting. But I don't expect it, because actually defendants getting on the witness stand is fairly rare. Um, and some of it is that in many cases the defendant has a history that the prosecution will bring in to prove that they are not savory people, that they're not honest, that they're um, so I doubt it. Um, I mean, I think it would be incredibly entertaining for all of us, but I suspect not, and I think that um, I seriously doubt that she will. Um, I think she will. I think that she's fairly compliant, and I think she will follow their advice. Speakeasy Lounge says she can't wait for CrimeCon. Me neither. CrimeCon is in early October or late September in Orlando, Florida, and we will post some links if you would like, because CrimeCon is a blast. Um, this last year it was in uh, in your hometown, yeah. Last year it was in Las Vegas at the Paris Hotel, and we had an absolute blast, and I'm really looking forward to seeing. It's so much fun to see all the folks that I get to connect with electronically, and I get to see them once a year, and it's super fun. Last year was the first time I went, and it was absolutely worth going again. So for those of you who might be thinking about it, we'll post a link and start telling people about it, because it's a lot of fun. Um, so Speakeasy Lounge, I will see you there. Thank you for posting the Quilt Guild information, Brown Eyed Girl. I think we'll take just a couple more questions. We're at the hour mark, and I don't like to take up any more of your time. We'll be back on Wednesday to talk about all the cases that are coming up. Apparently, there's been some developments in some of the cases that we're following, so I'll be interested to bring you some updates about those. Bo Peep, can you explain what a hostile witness is as it pertains to the Vallow and the Daybell cases again? I'm afraid I don't understand it. So a hostile witness is one whose interests are counter to the defendant, and it's not really invoked that often. So a hostile witness would be somebody who is counter to that person's interest. For example, they could call one of the Daybell children, and the Daybell children would be really hostile to Lori Vallow and her interests in the case. So it's not hostile like I hate you, but hostile like my interests don't line up with yours. And so for that reason, I would have a reason to shade the truth or to lie about it. And so all that it means is that if a judge says, yes, you can treat this person as a hostile witness, it means that on direct examination, the lawyer can ask leading questions. That's the only thing that a hostile witness means. It's not invoked all that often. And I don't know that it will come up in the Vallow Daybell case at all. I mean, I suppose it could if they were calling one of the Daybell kids like Garth to talk about what happened the night Tammy died. So, do I think Lori and Chubbs will put everything on Alex? would this raise reasonable doubt? Jennifer M. I think they'll try to put it all on Alex, but I don't know that it raises reasonable doubt. I think it's very typical for defendants to sort of point the finger at somebody else and say they did it. But you have to remember that involved in all of this is a conspiracy charge, a conspiracy that specifically says they conspired with Alex Cox. He's an unindicted co-conspirator because he's dead, but he's still a co-conspirator. And so try as they might to put everything on Alex and say he's the guy who pulled the trigger, or he's the guy who actually put his hands on the children and murdered them. That doesn't even begin to excuse them from the conspiracy. And conspiracy carries the same penalty as murder. So I don't think anybody should worry that them blaming Alex is going to somehow keep them from being prosecuted or being convicted of the crimes. So, well, I'm going to say thank you for the evening. Have a great weekend, all of you. And we will get together on Wednesday to catch up on a bunch of our other cases and the developments going on in them. So thanks so much for joining us. Michelle, get better. And everybody out there, have a safe weekend, and we'll see you on Wednesday.